Hi guys, it's Kathy. I hope you're doing well. I hope you're happy. I was having the best dream. Oh, but it's fine. Now I have crazy Karens to look at. So, here we go. Here we go. Here's some crazy Karens that we can enjoy.
All right, Ms. Hartley, 25M 689. And we were discussing pretrial readiness. I will note, Ms. Hartley, I'm going to tell you something that you don't want to hear, and that is I'm giving you a direct order not to yell at or threaten members of court
I didn't
staff.
threaten anybody. I didn't threaten anybody. I didn't threaten anybody. I did not threaten anybody.
Ms. Hartley,
Okay, but I understand. Okay.
members of court staff, members of law enforcement, the district attorney, or anyone else in this courtroom, or I will be forced to hold you in contempt, which I
Okay.
really don't want to do that.
Okay.
So I am letting you know that if you fail or refuse to comply with this order, which you have the ability to comply with, then I'm going to be forced to hold you in contempt.
Okay.
We have just a few minutes of conversation here today,
Okay.
and then you'll be released until your trial
Okay.
date.
Thank you.
All right. The people were informing the court of their good faith witness list. Mr. Clark.
Kaylani Hartley, Kristen, Walter, Ara McGinney.
This is hilarious.
And are your witnesses under subpoena?
Yes, Your Honor.
Nope, that's a lie.
Ms. Hartley,
Sorry, but it's a lie. Are they supposed to lie?
Ms. Hartley, right now is his turn to talk.
But
You
he's
and your
lying.
attorney-
He's not under subpoena.
You and your attorney can have a conversation
Okay.
about that outside of
Okay.
court.
Mhm.
Do you have any audio or video exhibits that you're seeking to introduce?
Sure we will, Your Honor.
Okay, I'll encourage you to have a conversation with defense counsel and bring it to the attention of the court in advance of the trial, whether there are any snippets, redactions, et cetera, objections that we need to address and not save that for the morning of trial. One full day estimated to be sufficient?
Yes, Your Honor.
Any motions in limine that you're aware of that we need to address?
No, Your Honor.
Are you requesting an alternate juror? And are you requesting the witness sequestration?
Yes.
Okay, I will order the sequestration of witnesses. The parties are instructed to advise their witnesses of the court's order. Nature of your defense.
General denial and freedom of speech.
All right, good faith witness list.
Kendall McAteer Sierra, an investigator employed by my office, and Miss Kelly Hartley, if she chooses to testify.
And you're ready to proceed to trial on the 11th?
Yes.
Any motions in limine that you're aware of that we need to address?
No.
One day estimated to be sufficient.
I think so.
All right, and are you requesting an alternate juror?
No.
And are you requesting the sequestration of witnesses? Oh, I've already ordered it. Are you requesting that law enforcement be excused from the panel?
Yes.
Which version of the beyond a reasonable doubt instruction are we seeking to use?
Our request is the old one.
It's okay, Your
All right, I'll remind the parties of the pretrial order that entered when Ms. Hartley entered her not guilty plea. And let me just pull the trial date. I think we still have several set that day, but I do not think, let's see. No, I was wrong. This is the only one set that day, so Ms. Hartley will proceed to trial on the 11th. Ms. Hartley, I encourage you to discuss with your attorney appropriate jury trial behavior. If you are unable to conform your behavior to the court's expectations, you could face being held in contempt. You also
I'm sorry. It's
You
not
also
just
may
about-
voluntarily absent yourself
Okay,
from
I
the
apologize. Okay,
proceedings.
I get it. I get it. I understand.
All right, we'll see you at 8:30 sharp on that date.
I did just have one more thing. I guess this could be a motion to eliminate. The district attorney is indicating that they're going to call Officer McGinney. The only thing Officer McGinney did in this case was arrest Miss Hartley, and the district attorney had indicated that they would not be seeking to admit any statements that Miss Hartley made during that arrest. That was the subject of one of my motions that we ended up not going to a hearing on because of this representation. So I just feel the need to put that on the record in this moment.
So the people are on notice. I don't have an offer of proof as to what her testimony may be, but the people did indicate, and the court's notes reflect that the motion to suppress statements motion was moot because the district attorney agreed not to be introducing statements of Ms. Hartley from the time of her arrest and transport to jail. So the people are certainly on notice of that, and how they decide to proceed from there is up to them. Anything further? No. All right. Thank
No,
you.
actually. Thank you for failing the 2 cases on my
Ms.
husband,
Hartley,
Damian Montes, and thank you for
Ms. Hartley,
letting him go free.
Ms.
Thank
Hartley,
you.
that's
Thank you.
enough.
Thank you.
That's
You
enough.
almost killed me several
Go.
times. You guys did nothing. There's no justice here.
Ms.
Tell my daughter that they did nothing, to save the fence. Nothing. So you guys are.
Ms. Hartley, you're excused. Thank you.
But don't want to have a problem. You're not going to work with me. You're not going to follow me. I'm not.
I will just note for the record that Ms. Hartley has had another outburst on her way out of court. The court notes that she vehemently disagreed previously with threatening officers, although this court distinctly heard her.
I'll just note for the record that even though the court said it distinctly heard her, it did not hold her in contempt, as it should have.
Indicate that if an officer pointed at her, the finger would be broken. This court will not tolerate such behavior and will not tolerate such behavior at a jury trial. And Ms. Hartley will be expected to conform her behavior to the expectations of the court. Mr. Welsh.
Judge, I can call Mr. Medina.
All right.
Funky cold what?
I have a Sarah Cosgrove seeking admittance to the WebEx. Does this person ring a bell to anyone? All right, Mr. Medina appears in person. I'm sorry. Oh, here. With Mr. Welsh. Mr. Medina, come on up and stand with your attorney. This is 26M161. And we do have Mr. Welsh here on your behalf, and Mr. Tommy is here for the people. We had set the matter over from Friday to parse the new contours of SB 26149. Although quite a lot has changed pursuant to that law, it appears to me, and it's rehoused essentially in
I think it's 16, 8.5, 110, 1.
1B. So rehoused into the 110, which previously was a single paragraph and now is quite a bit more than that, but that this hearing must still occur within that 7-day period of time. We are still within the 7 days. That the standard remains the same and is applicable here. So where we had left off, let me just get to that. And that relates to specifically under 1B, if the defendant is in custody in a class 1 misdemeanor, et cetera, the court shall set the hearing. At the hearing, there is a presumption that the court order a personal recognizance bond and enter an order for restoration services. If the court were inclined to deny a PR bond, the court must make findings of fact that extraordinary circumstances exist to overcome the presumption of release by clear and convincing evidence. So, Mr. Tommy, are the people seeking to overcome the presumption?
Yes, ma'am.
Okay, and in what way are we doing that?
Just probably have, Mr. Lujan is here. We'd probably have Mr. Lujan testify as to the danger of Mr. Medina being out and the danger to him and Mr. Medina's mother and inability to, live at the home because of protection order and probably being homeless and those sorts of things, Judge.
Okay.
Is that what you're looking for?
So I have to be able to make findings of fact that would then have to be reduced to writing to CDHS as to why, if you were able to overcome the presumption, why that occurred. So if you're seeking to do so, then go ahead.
Can I talk to Mr. Lujan real quick?
Sure.
Be all right if Mr. Medina took a seat.
That is perfectly fine. You can have a seat right there, Mr. Medina.
Your Honor, I guess from a procedural standpoint, I can put Mr. Lujan on the stand or he can come up and talk to the court. Also, Your Honor, may we approach?
Parties may approach.
Of our June Friday docket summer calendars. Just in case you were worried.
I knew you'd figure it out.
I actually did.
All right. Mr. Medina is out from the holding cell. This is 26M 161. And Mr. Welsh or Mr. Tommy?
Your Honor, the people would call Sandy Medina.
Okay. All right, Ms. Medina, you can come on up here and I'll swear you in. Raise your right hand for me. Do you solemnly swear or affirm under penalty of perjury the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay, come be seated right here.
Don't grab me like that. This ain't a show.
All right, and if you could state your name and spell your last name for the record, please.
My name is Sandra Medina, Medina, Medina.
All right, Mr. Tommy, when you're ready.
All right, thank you, Your Honor. Miss Medina, do you know Matthew Medina?
Yes, that's my son.
And has he been living with you lately or the last few months or before he went to jail?
Yes.
How long has he been living with you?
For most of his life.
Has he always kind of had some problems?
Yes, he's had mental health issues. Yes.
But just recently it was enough where y'all called the police.
Yes.
And
Yeah.
what was that circumstance?
He pushed my boyfriend. I was inside, but he pushed him. He was out in he went to get in the RV and he pushed him forward and he fell.
And that's Mr. Lujan.
Yes, that's my
And
boyfriend.
he is, he doesn't walk well anyway.
No, he's disabled. He had a stroke.
Has Matthew Medina hit you before?
Yes, but I dropped the charges because I wanted him to get the help he needed.
I understand, but he has hit you before.
Yes.
Has it been more than once?
Yes.
Several times?
Yes.
Has he thrown you up against the wall or against the door?
Yes.
Are you scared of him?
Yes, I do. Since he's not on his medicine or anything, I do fear for my life and my safety, and so does my boyfriend, Delano Lujan.
How is he when he's at the house?
When he's not on his meds, he's up all night. He argues, he breaks things, he hits us. He's unpredictable. You just never know what he's going to do.
And you have a protective order against him at this time.
Yes.
You don't want him back in the house.
No, I want him to get the help he needs. He needs to go to the hospital and get on his meds so he could, be better, not be so violent and sleep and stuff.
Has he been on meds before?
Yes.
And how has he been when he has been on his medication?
He's okay. He's a different, so like at night and day, he's a different person.
With the protective order in place, if he is let out of jail, does he have a place to go live?
No, he would be on the street and I don't want that. That's not safe for him either.
Do you have any concerns about Mr. Medina harming himself?
Yes, I don't think he's not safe for himself or anyone else, for me, my boyfriend, for anyone.
And you are in fear for your life if he's around the house.
Yes,
There's no peace when he's there.
there's no peace at all. Because we never know what he's going to do. We can't sleep. He's up all night, tearing the house up, arguing with us.
But you're wanting to get him some help.
Yes,
Think he can get it just being out in the community through outpatient treatment?
I think he needs to go to a hospital, a treatment center.
That's the only way you think he can get any help.
Yes,
And how, you've been around him all your life.
yes,
That's that's your opinion of what kind of help he needs.
Yes.
Ask the witness.
Cross-examination for this witness.
Yes, Judge. Now, you said that, that Mr. Medina had pushed Mr. Lujan. Is that correct?
Yes.
But you said that Mr. Lujan doesn't walk very well on his own,
No.
right?
He limps. He's had a stroke, a major stroke.
And that as you said, he's had a stroke recently. And you said that Mr. Medina, when he is on his medicine, is not a danger to you.
No.
Okay.
He's okay.
And has he been on his medication before while being out of custody?
Yes.
And like you said, like we mentioned, there is a protection order that he's not allowed to come back to the house currently.
Yes.
And you mentioned that he would be on the streets, but
He's waving to someone in the gallery, but I don't know who it is.
do you know if he has any other? You wouldn't know if he has other connections to a place to stay,
Not that I know of. He doesn't have no place else to go.
but there could be someplace potentially.
I can't say. I don't
Okay.
know.
No further questions.
Nothing else from the people, Judge.
All right, thank you.
Thank
You may
you.
step down. Argument from the people.
Yes, Your Honor. This is a sad state of the mental health things that are available to people. We're between a rock and a hard place. And I understand the law says he's entitled to a PR bond. But we're in a situation here where his mother she doesn't want him back in the house because without meds, without any kind of medications, he's up all night. There's no peace in the house. He hits on them. There's violence in the house. They're scared of him. They are in fear for their life. There's a protective order in place, so he can't go back to the house. Nobody's presented. I mean, they don't know where he could go. He would be out in the community without any medications. He's probably going to be homeless. No telling how he will if he hurts somebody else or does something even worse. He'd be back in jail. He might be back in jail again in no time just because of that. And I understand everything here. So it's always a question, where do you draw the line on all this? But I think to give him a PR bond and let him out would be disastrous. And, what is extraordinary? What good are we doing for him to say, okay, well, you're free to be out of jail when there's no place to go, nobody to take care of him, no medications, no nothing, and he's out roaming around and he's a violent individual, according to Miss Medina. You're putting the community at risk. You're putting him at risk. He needs to stay in jail. He doesn't need a PR bond, Judge. And I think those are extraordinary circumstances that he just doesn't need it. It's not fair to him. It's not fair to Miss Medina and Mr. Lujan, or fair to the community that he be let out on a PR bond. And the people really request that not to issue him a PR bond in this case. I just think it's a terrible situation, and nobody wants him in jail, but that's where everybody is safe. And that's a bad deal, but that's where everybody's safe. So we're asking to deny the PR bond and set a bond where he would stay in jail, Judge.
Thank you. Mr. Walsh.
Judge, what we've heard from Ms. Medina is that when he is out of custody and on his medication, that he, when he is receiving treatment, that he is not a problem. That is precisely what we're asking him to do, is to get.
You shall get an outburst-ish, Bobby. You shall. We have to wait for the lawyers and the judge to talk first. It's a tough one for the judge. This one is a nail biter.
To do the restoration services that would probably include that sort of treatment. And Mr. Medina would be able to get that while outpatient. He'd be ordered by the court And further, as to the, the fear of Mr. Medina, he is still under the protection order that keeps him from the house where they live. So I think that there is that mechanism in place to keep him away from them that should deal with, any sort of fear of Mr. Medina's behavior. And again, we do, I believe we have bridges appointed in this case. We have people who are, able to help Mr. Medina with finding a place when he gets out, or at least giving some direction. While we don't have a place in mind currently, I do think that's something that our social workers can help Mr. Medina with. And I don't believe, again, these are unfortunate circumstances, but I don't believe that they're extraordinary circumstances. I think that these are the same set of circumstances that are dealt with in the majority of competency cases and that are contemplated by the statute. I think that, even the facts of the case that were discussed today, Mr. Lujan was, doesn't walk very well. He's recently had a stroke. I think when it comes to the allegations in this case that Mr. Medina pushed him, I think that, the whatever actions that Mr. Medina may have taken or, are alleged to have done, would be in line with, an unfortunate accident. So I do not believe that there are extraordinary circumstances here to rebut the presumption of a PR bond.
Well, I think a couple of things. One, I'm not hearing any argument about case law in relation to what extraordinary circumstances are under these particularized circumstances. I don't know of any, frankly, but that doesn't mean that a creative attorney couldn't find some. But I'm not hearing that. So the court is somewhat without guidance from a legislature that has put in place a rebuttable presumption without specifically defining what that looks like. I will note that when we are talking about this extraordinary circumstances, I do think that, first of all, the hearing is only available under these circumstances to individuals who are not otherwise eligible for mandatory dismissal provisions, so not the very lowest of levels of misdemeanors or petty offenses, traffic, etc. It also is not something that is statutorily enabled for all felony level offenses. It is specifically class 1 misdemeanors. I'll note that the modification to the statute that went into effect last week excluded, again, those lower level misdemeanors, the M2s, the petty offenses or the traffic offenses. So it is M1s and DUI type offenses not relevant here. Those are the only
Brent has a gun? No, he wouldn't miss.
cases that are eligible for this type. So the legislature obviously has thought about the varying statutory arrangements and looking at what that means more specifically. So we are not looking at circumstances where someone is charged with a felony, but what would be an extraordinary circumstance in a class 1 misdemeanor? Again, class 1 misdemeanors typically are cases which do not involve a very serious or extreme risk. Now, they can, and I do not want to say that individuals charged with class 1 misdemeanors do not pose a serious or extreme risk. So the court needs to look at a totality of factors when making this determination. And again, the court needs to make that determination by clear and convincing evidence. What I am hearing, and I have limited evidence, I do take judicial notice of the court file as well as the competency evaluation. So the opinion of the evaluator there. Again, the court notes that Mr. Medina was found to be incompetent to proceed. He was also found to be restorable. He was found at tier 2, but restorable within a reasonable period of time. I will note that by my understanding, Mr. Medina has 14 prior convictions, including 4 third-degree assault convictions and 1 second-degree assault conviction from 2019. That does not mean that Mr. Medina necessarily is going to commit a new act of third or second degree assault, but the court does have to look at those factors. I also see, for example, a felony menacing from 2007 at the class 5 felony level. I see felony level theft offenses, again, theft not directly related, but there is some pretty significant criminal history and violent criminal history. What I have heard is that Mr. Medina is able to be very stable if he is on medication. When he is not medicated is when, according to the testimony of the only witness that the court has heard the testimony of, is when he behaves in this other way, unpredictable, hitting them, etc. He was described as violent, but a different person when he's on his medication. But what I'm also hearing is that he's not currently on his medication. At least that's not the indication that the court has received. The court also does not penalize Mr. Medina for potentially being unhoused. That's not something that this court can or does weigh in on. I do look at that as a stability factor, however, and stability is something that is necessary if Mr. Medina is going to be successful.
I would definitely, absolutely take food from a strange old woman. Yes, I would. Thank you.
Successful with restoration services. I'm not hearing, and I know that the burden is clear and convincing evidence. I'm not putting any burden on the defense, but I'm noting for the record that I'm not hearing any stability factors in place. And that is a concern. Again, it is not the burden of the defense to prove to the court. But what I am hearing from the testimony that I have received is that there is a lack of stability factors. And that is evidence that the court has that due to the protection order, Mr. Medina will be unhoused, that according to the sole witness that testified, there is no alternative location for him to reside. The logical inference being that he would be unhoused. The court is aware that under those circumstances, again, with the totality of stability factors, that it is much more difficult for an individual to get to where they need to be to take the medication that they may need. And under the circumstances here, that leads to, or can lead to a violent circumstance, which I'm concerned about. I'll also note, it appears as though Mr. Medina has been convicted in the past of violations of protection order. The court doesn't seek to hold Mr. Medina's criminal history against him. However, I do need to consider as a stability factor and a safety factor, whether or not he is likely to comply with court orders. And I'm concerned about the safety of all individuals involved, including Mr. Medina himself, although I'm not keeping him in some sort of protective custody. But I'm concerned about the safety, according to the testimony of Ms. Medina, for herself, for Mr. Lujan, and potentially for Mr. Medina himself under those circumstances. I'll note that some of the testimony, although I recognize is concerning, is not as compelling to the court, simply because of the standard that the court has to consider, being up all night, arguing, breaking things while potentially disruptive, annoying, or even illegal, does not typically rise to the level of an extraordinary circumstance. However, the allegations of violence in this case, coupled with the track record of violence in other cases throughout a significant period of time, the court makes an inference that may be when he is not, when he may not be taking his medication, or at least not have a medication that's properly calibrated to assist him. Sorry, I'm looking for something specific in the evaluation, so just bear with me for a moment.
You know, those cool kids that grew up.
So there were some specific statements in the evaluation, including summaries of reports coming from the detention facility about the necessity of Mr. Medina to be on lockdown, in restricted housing. It looks like a number of different reasons, but that Mr. Medina has exhibited aggression and violence within the jail.
Salty, just looking at that jail view, I can hear Judge Manning. I can hear her. North 3, wake up. Get your head up, North 3. I'm not going to tell you again.
There was one other thing, just a moment. So, on page 17 of 18, it discusses that Mr. Medina is not currently amenable to taking any prescribed medications, and his symptoms may improve with treatment adherence. Seems as though that may have been something that occurred in the past. This court is not seeking to impose, I don't have the jurisdiction to impose involuntary medication, first of all. But second of all, the court is not balancing essentially taking medication versus a PR bond. That's not what the standard is, and that's not what this court intends to do. But it appears to be that there is a track record that one of the things that can be helpful for him is medication, and that's essentially corroborated by the testimony of Ms. Medina, who knows him obviously very well, having been his mother for the entirety of his life and having been around him.
Tomorrow might go. Well, I don't know. Tomorrow it's possible tomorrow. They switch judges in Colorado and we get Judge Eric back.
For that time. Under the current circumstances, I'm denying the PR bond. I do find that these are, under these current circumstances, extraordinary circumstances. And again, we're talking about extraordinary circumstances within the confines of Class 1 misdemeanors, DUIs, and DWAIs. That's what the legislature has specifically delineated as eligible for this hearing in general. And so the court must make a logical inference that what an extraordinary circumstance.
One of those crimes just pissed him off really, really, really badly. And we're going to hear about it. Don't worry.
as looks like for an individual on a class 1 misdemeanor is different than an individual who may be charged with a felony
There's
level
Dee.
offense.
Dee's here. Hi,
The
Dee.
court notes that I make that finding by clear and convincing evidence. I have heard the testimony of Ms. Medina. I have also reviewed the competency evaluation as well as Mr. Medina's criminal history. At this point, I will order in custody restoration. I am also happy to revisit this
No
issue
PR bond.
if either party, I'm sorry, I will also appoint the Bridges program. But if either party or Bridges or some other individual, I know that family members are sometimes able to assist in this way, but wants to present to the court
Thank you,
some
Margaret.
mechanism to alleviate some of these concerns that have amounted to the community safety issues and to the finding of extraordinary circumstances, including ideas for medication adherence, including housing and stability factors, support persons, et cetera, noting that there's a protection order in place. And so those individuals who may have otherwise been able to provide that type of assistance in getting to appointments, et cetera, are unable to do so. I'm happy to reconsider that. I don't want Mr. Medina to have to remain in custody or at least to have the bond set as it is. But I don't think under these circumstances that the court can grant a personal recognizance bond.
Thank you, Judge.
So we do need to set a new date. And when do you want to schedule that?
We set a review for the 25th.
We can. June 25th at 8:30. Mr. Medina, we'll see you then.
Can I say something?
You can, you don't have to. Anything that you say can be used against you. So you might want to listen
Here we
to your
go.
attorney about exercising your right to remain silent.
Well, I just would like to say, that, you mentioned the Bridges program. Where is it?
So they are individuals and they have a business card that's right there. So Mr. Welch,
I can't hear every single word he says, but I get the gist.
if you want to get Mr. Medina a copy of that. Typically, there's 2 individuals, sometimes 3 that work in this region, including someone named Kim.
No stream tomorrow morning. We do stream tomorrow night, but not tomorrow morning. Unless you live in Australia, then I don't know.
Someone named Alicia, and someone named Cinnamon. So any one or more of those individuals may reach out to you while this process is ongoing.
You said something about a DUI. I did fight that case. I
No,
just want to say.
I wasn't talking about you. I was talking about,
The only one that's really here.
I'm sorry, I was talking about the statute. I was talking about the statute.
DUI. I did beat the DUI. So you should, and I've been doing good. I've been talking, and I'm not violent anymore. I did get the kill for it. Now, the thing is, when you see something very violent, you should at least have a stated opinion, which I did see something very violent, right? And it was a sad situation.
I'm
So
sorry
I
to hear
did
that.
turn it in. If you do your, well, I believe you're a doctor in all this, so you at least have to go to school for 8 years, right?
I'm not a doctor.
You're a judge.
I am.
Well,
It's a little different. So going to law school is different than going to medical school. I suppose we have a Juris Doctorate, but that's a little different than a medical doctor. I am not a medical doctor. So any prescriptions or diagnoses that you receive from a medical doctor are something very different. I'll just note for you, I was talking about the statute as it talks about class 1 misdemeanors, DUIs, and DWAIs. I was not intending to imply that you have been convicted of a DUI. So I was just talking about the statute in general. Okay.
can I tell you a little bit more about, the main why I'm here for, Tomas Lujan. Is that correct?
Thomas Delano Lujan is a named and alleged victim in this case. I would encourage you not to talk about the facts of the case here because we're not really at that type of a hearing, okay?
Well, I just want to say something now. about her. Well, no, she, well, it's fine. You know, I'm not just gonna sit there and stay quiet like, some people. Like I said, I've been doing good. Well, I mean, the best I can. And I do have a medical issue. And, you know,
Okay, well, I encourage you with your medical issue to speak to a medical provider because that's not me. And I encourage you with how you're telling me that you're doing good to speak with Mr. Welsh. He can help you get more information to me if you and him decide that that's in your best interest or appropriate. Okay, so you and Mr. Welsh can work as a team to get me some information.
how many charges do I have? So I got two Moss Lujan and, two Moss Lujan's woman that I bashed in again now. And, I know there's no bruises on her. I know she doesn't have anything. So I got two charges now.
I know there's no bruises on her.
This one is one. It's one count of assault in the third degree. Okay, so we'll see you on.
I just want to say something good about myself. Now, two Moss Lujan did mention something. He mentioned that, he couldn't have kids, right? And I'm no good with kids. Now, he mentioned all this stuff, and you know, him and his woman were just, you know, having a lot of well, good times. And he said that somebody just, you know, fixed it. Meaning something went out of his body, the whole thing, and you know, over 20 years later, I haven't been here since, well, last year I left. So, and I know the way you talk, they're going to say that like you said, I've just been with them the whole time and they've been taking care of me. It's a new year. I arrived back, right? And the thing is, there was a little baby that, I understand. You know, I would have to wipe this baby, you know, the face and everything. The only thing that I didn't understand is, two Moss Lujan would tell me that I'm going to be eating certain animals. So I was nice and said, I'm not going to do that. And these animals are, yeah.
Okay, let me interrupt you for 1 second, okay? So a lot of your concerns are a little outside of what we're here to do today. So I would encourage you to have a conversation with Mr. Welsh if there's other things that you want to bring to my attention. But I'm going to see you on June 25th at 8:30, okay?
And
All right.
the lady's name, though, I wanted to say it was Zuri. And you know, Zuri is, yeah, and he says this one just, you know, my mother, well, had it.
Okay, well.
You understand that, and I know.
Sure, but you can talk more about this with Mr. Welsh. So I'm going to see you on June 25th at 8:30. Thank you so much.
Do the medical record go on? Never,
Thank you, Mr. Medina.
as for the baby. Like, thanks.
All right, Mr. Welsh.
I can call Mr. Shelton.
Zuri.
Okay. 6M206. Oh, I'm sorry, he's not walking out yet.
And Your Honor, fair warning. I have some competency concerns and he may be a little bit agitated. Just so you know.
Thank you. Seems to be
This judge is having a
the
day,
story
guys.
of the day. that
Yeah,
people
we're
are
having a
not
vocal
happy with
day.
us. So,
What you get, Judge, for setting all these cases.
Snoopy.
Oh,
all right,
Was that a
Mr. Owen is out from the hotel.
you?
Good, thank you. Come stand with your attorney.
Way right now, man.
Yes, perfect.
Oh, I know somebody right there.
All right,
That's my girlfriend. She got a frown on.
come, just,
What's up, man?
Mr. Owen, I need to say a couple things for the record, so
You
hold
go on
on.
ahead there, Miss Robar.
Sometimes I think Snoopy and Donald are the same person.
Right.
I'm right here.
This is 26M269, 26M206, 26M297. Mr. Owen appears in person with Ms. Hamilton. We do have Mr. Tommy here for the people. Good afternoon, Ms. Hamilton.
Your Honor, a couple things. I do have some competency concerns. I will be looking at possibly filing that motion in after discussion with his other attorneys.
Another attorneys?
Can I please finish?
Yes, ma'am. Go ahead.
Thank you.
We'll take it. Sure.
I would ask you to just let me finish speaking to the judge. Okay.
Gotcha. Cover.
Appreciate it.
Beat me up, Scotty.
All right. So
Never,
I am
never,
going to be
never.
pursuing that. I need to talk with Mr. Owen again outside of court to do that full assessment. In addition, Your Honor, I have tried to speak with the district attorney to see what options may be available. When I did that, he indicated that they might be looking to file one of these cases as a felony.
Shit.
So,
I don't do nothing.
so,
On my record. Look at my record.
Hold
Let
on,
that speak for itself. Can it speak for itself?
Mr.
Have I
Owen.
ever done anything to anybody?
Hey.
Look at my record.
Mr. Owen, she's trying to defend you, okay? So let's let her finish and then we'll hear from the people, okay? And so you're looking to set this on which day, Ms. Hamilton?
Your Honor, I would ask to set over,
Got my car stolen.
second or the 9th. And again, it was the prosecutor who's talking about filing as a felony.
All right.
So we do need to explore all that.
Any,
Thank you, Judge.
any objection to a continuance for that purpose?
No, Your Honor. I just told Ms. Hamilton this earlier. Not so much me, the felony attorneys are looking at filing a felony case in,
Looked at my record, Kyle?
7. I would suggest we set it over for the 9th to see if we get that done.
Yeah, all right.
Okay.
Do that.
We'll set this over to June 9th.
Didn't matter, so-
2:30.
This.
All right. I'll let you know, these 3 cases are not holding you, Mr. Owen. You do have one in the district court. That is the one.
This Judge, Your Honor, I would like to
See,
say this.
which
Never
one?
looked at my record and
Holding
see how
it.
clean it was, and that's because I have worked all my life for my children. This one right here doesn't know so much, so I would like to have somebody that knew a little bit more. I'd like to spend more than 1 minute with a lawyer, really, to be honest with you. I've yet to
Sounds like-
talk to one lawyer for more than 1 minute.
Sure.
Been under lockdown for about 8 days, which explains my not so funny demeanor. Now, the fact that they even want to file felony is felonious by nature.
So, Mr. Owen, hold on, okay? Mr. Owen, so you have one felony case. Mr. Rosen represents you there. Ms. Hamilton represents you on these misdemeanors. Sounds like she's intending to come talk to you and make some decisions about how you'd like to move forward. So we'll do that on June 9th at
Innocent.
2:30.
I have not done anything, really. I mean, I hit a girl, but the girl hit me.
All right, we're not gonna get into
Hit a guy, he
those
was a biker,
details
but
at
he
this
wasn't a
moment.
real biker.
Make statements about the case.
Man, this is my case. This is the way I go, all right?
Which
If I want
are
to
you
tell
show
the
holding him?
truth, the truth is the truth, is it not?
Hold on, Mr. Owen.
Was
Which
it
matter is
top-rated?
holding him?
I couldn't hear.
Which matter is holding him?
I'm not sure.
Oh, you don't have, it's not on your green sheet?
We don't even
I
know.
believe 26M297 is holding him on a $1,000 cash surety.
I'm not worth $100, man. So that's why I'm defending myself.
Yeah, it's not in there correctly.
$100 for a bond? Ooh.
You're not really.
Man.
defending yourself,
$26M297. Okay. We'll
I
get
mean,
back to
3
that date.
days. I would be
Thank you.
$500, $1,000.
Thank you, Mr. Owen. So I'll
Thank
see you on June 9th at 2:30.
June 9th, sounds like a date.
It is.
All right, let's take a step up.
All right.
See you then.
All right, still staying in jail? Hi, baby, how are you? You're doing a great job. Thank you. Keep up the good work.
All right. And are we ready on Mr. Moore, who is completing an
Thanks,
application?
baby. I'll be in jail. You know, you stay outside jail.
Mr. Owen, I'd encourage not to speak to people with whom you have a protection order.
Man, that's my girlfriend.
Thank you so much. All right, Mr. Moore?
T case, there was a complaint filed alleging that you violated probation. A warrant was issued and bond in that case has been set in the amount of $5,000 cash or surety. In the 26M1603 case, there was a finding of probable cause based on a review of an affidavit. Judge who reviewed that issued a warrant. There's currently no bond set. The charges alleged against you in that case are third-degree assault, harassment, false imprisonment, alleged to be acts of domestic violence. The court is going to issue a mandatory protection order today in that case and set a bond. For the record, is the listed victim present in the courtroom or in WebEx? I'm not receiving any response.
Bobby, would you send me to prison too? Would you just make me guilty?
Ms. O'Hara, has your office had any contact with the listed victim?
Not to the best of my knowledge, we attempted, but were unable to make contact today.
Judge, if I may, it's Ms.
Yes.
Bratton. I believe Ms. Kayla Molina has passed. Mr. Anderson indicated that she had a heart attack in March.
Oof. Oof. Okay, so I think the victim died of a heart attack, okay? But I don't think she's the only victim. I think there's another case with a different victim, but I'm not sure. But it does get worse.
And I was able to confirm that through an obituary online.
Okay, thank you. I appreciate that additional information, and I'm sorry to hear that. Ms. O'Hara, what's the people's position in regards to the mandatory protection order and bond?
Your Honor, with the protection order, we're gonna, at this point, just because that's new information, ask for a full no contact. It doesn't sound like there would need to be any exceptions at this point, obviously. With bond in the
That's why I think there's another victim. Because why would you make full no contact on a lady that passed away?
26M case, the people I'm still going to
Thank you,
request
Snoopy.
based
Thank
upon criminal history and information that I see until we have some time to verify things, and then I think bonds and whatnot can be readdressed. But the defendant, pretrial is reserving judgment. He does have a 2023 DUI, which the court is going to address the violation of probation allegation here in a minute. There's also in 2015 two protection order violations as well as a third-degree assault that was an act of domestic violence. Then there are a 2013 disorderly as well as some older drinking and driving offenses. For those reasons,
I'm thinking of committing a crime right now, Bobby. I'm thinking of stealing Eileen's cashews.
in the 26M, we're requesting a $5,000 cash or surety bond.
Thank you. Ms. Bratton, have you had a chance to speak with Mr. Anderson about his right to have a hearing within 14 days?
Yes, Judge, and he is waiving that right and asking for a disposition date on the DUI matter.
Okay. And do you wish to be heard in regards to bond in the protection order in the 26M case?
Yes, Judge. Given that bond is $5,000 in that traffic matter, Mr. Anderson cannot afford any additional bond on top of that. I would be asking for a personal recognizance bond. He's in a risk category of 1. Ms. O'Hara is correct that pretrial service is leaving judgment up to the court. However, I believe the primary reason they did that is because there was not an affidavit at the time available for them to review. I can tell the court, since his partner and the alleged victim in this matter has passed, he has taken over sole responsibility of parenting for her 3 children. Their biological father had also passed about 7 years back. So currently it's him and her 3 children at the house. Their ages 21, 19, and 13, but the 21-year-old and 19-year-old still rely on him for housing and for financial support. Their rent is due coming up on June 1st. Mr. Anderson turned himself in on this matter. He had been in communication with his parole officer. She advised him of the warrant. He turned himself in. Judge, he does work at a manufacturing plant. He's had that job for a long time. He's currently a team lead. He's responsible for 5 other members of that job. He's been in Colorado since 2007, and Judge, just given what the family has been through, my request would be for a personal recognizance bond.
Thank you. The court is taking into consideration the bond set in the other case. In the 26M case, the court will set bond in the amount of $1,000 cash or surety with conditions that Mr. Anderson comply and sign and comply with the mandatory protection order, that he not possess any weapons, firearms, or ammunition, and that he remain law abiding. I am going to issue a mandatory protection order today. At this point, it will order that he not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts that he is alleged to have committed. Ms. O'Hara, let me start with you, Ms. Bratton. Is your client currently residing at the 16th Street Road address?
Yes, Judge, he is with the children.
Okay. And Ms. O'Hara, do you have a position? I guess I'm a little concerned about restraining him from that location if,
I'm fine if is the court comfortable not putting any address in the protection order?
I'm fine with that. I just wanted to check in with both of the parties.
That's fine with the people.
Okay. The protection order at this time will order that Mr. Anderson not harass, molest, intimidate, retaliate against, or tamper with Ms. Molina, that he have no contact with her directly
Margaret, I agree.
or indirectly except for third-party adult contact for parenting purposes, that he not possess any weapons, firearms, or ammunition, and comply with the court's relinquishment order. Mr. Anderson, your next court dates for both cases, if you're out of custody, is June 18th at 11 o'clock in Division 8. If you remain in custody, it's June 5th at 9 a.m. in Division 8. Do you have any questions that I can try to answer for you today, sir?
I do not.
Okay, court is in recess on these cases.
Next, Your Honor, I have number 8, Mr. Tolliver.
Thank you. The court calls People versus Elgin Tolliver, 26M 1822. Mr. Tolliver, do you have any questions about your rights as explained to you in the packet that we sent you to read through?
Yeah, but no, I'm just kind of confused about everything.
Okay, is there a specific question that you had?
Me too, sir. Me too.
No.
Okay, have you ever served in the United States military?
No.
Do you own or have access to or control over any firearms, weapons, or ammunition?
No, ma'am.
And Deputy, did he check the no on the relinquishment form and sign it?
He did, Your Honor.
So the court has reviewed the affidavit in support of your warrantless arrest. I have found that there is probable cause. The one charge alleged against you at this time, sir, is third-degree assault alleged to be an act of domestic violence. The court is going to issue a mandatory protection order today and set bond. For the record, is the listed victim present in the courtroom or on WebEx? Not receiving any response. Ms. O'Hara, has your office had any contact with the listed victim?
Madam, I had notes that she was on WebEx, but I don't see her either.
It looks like possibly, maybe.
Don't you worry. Is that O'Hara? I can't see. It's all. She's here, guys. And we're going to hear from her. And then we're going to hear from her friend.
Up at the top, I don't have a last name.
Oh, yes, the court could be correct. I do have some input if the court could just bear with me one moment as to look at that. She wasn't sure if she wanted to address the court, so if the court could inquire.
Sure. Ms. Eberbelding, do you wish to address the court? You're not required to say anything. I am not receiving any response.
Your Honor, she did indicate.
I'm sorry, she put in the chat, yes, my friend is here with me also. So Ms. Eberbelding, if you would like to address the court, if you just want to unmute yourself.
Can you hear me?
I can, yes, thank you.
Yeah, I mean, I'm entirely confused about what happened that day. It was kind of early in the morning. I wasn't aware of what was going on. He had taken my truck the night before the day this happened, and he never came back, and he brought it back, and the battery cable was somehow broken off, and I I can't even start it. I can't even roll up my windows anymore, and it's about to rain.
And I'm here too.
And yeah, a girl that was here with us during this whole situation is with me right now.
Okay. Is there anything you would like to say in regards to bond or the mandatory protection order?
I don't have anything to say about bond. I'm afraid to have him around me if he is going to hurt me. Like, you know, I mean, he didn't hurt me during the situation, but we wrestled the night before, and you know, I had bruises everywhere. That's why they took pictures. But I'm not afraid of him hurting me.
Can I say something?
Yeah, she wants to say something too.
So this is Elizabeth Pine, Elizabeth Staten.
Can you hear her?
Yes, I can.
Okay.
All right. You were my lawyer before.
I'm sorry.
You were my lawyer before. This is Elizabeth Staten, Elizabeth Pine.
You mean someone from the public defender's office was your lawyer before?
No, actually, I think you were, but the public defender, I do have one.
Okay, I don't think it would have been the court. I have never been a defense attorney, so, but go ahead.
Okay, so he did bring me here because I was in trouble and something did happen to me. I got hit in the head or drugged or both or something. That day he got arrested and I got arrested too that day.
And I'm sorry, Ms. Fine, I'm not sure what you're referring to, so I don't know if there's a separate case that's not in front of the court today. Right now, I only show one allegation with Miss Eberbelding being the listed victim. Is there anything else that you?
Sorry, everyone says it wrong. No, she was just wanting to make a statement that she was here during that time, and
yeah, and they did, in my opinion, save my life.
Okay,
we're talking about the case right now.
And so, I'm not sure what else I have to say.
I don't know why she wanted to say something, but she's saying.
Just as a witness.
Yeah.
okay, thank you. And I'm sorry, is it pronounced Erbelding? I apologize if I mispronounced it.
It's fine. Everybody says it wrong.
That sounds delicious.
Is that how you pronounce it though, is Erbelding?
Erbelding, yes.
Okay, thank you. Thank you both. Ms. O'Hara, what's the people's position in regards to bond and the mandatory protection order?
Your Honor, just so the court's aware, when we did speak to Ms. Erbelding, she is requesting that there be phone contact between the parties. They don't share children, but they do share a residence, and she didn't have any specific input on the bond. I would note the defendant does have an elevated DVSI score of 14. He has a risk category of 3 with a total of 14. They're reserving judgment. He currently has some cases pending out of Larimer County. One is 26 CR 624, which is a prohibited use of a weapon. And then 26 M 598, which is a possession of an ID doc. He's also on probation, it looks like, for a 26 DM1 case. His criminal history is fairly lengthy. In Colorado, there's a few more entries, such as attempted third-degree assault, another DM1. There's a 2023 attempted third-degree assault as an act of domestic violence. The majority of his history is out of the state of Ohio, and it was very lengthy, and include drugs offenses, weapons offenses, drinking and driving, things of that nature. In light of the fact he has those cases pending and is currently on probation, obviously that causes the people concerned for the defendant's willingness to remain law-abiding and to follow court orders. When law enforcement did arrive, it sounds like they arrived for a different reason, but then it was reported to them based upon the defendant going back into the home and not abiding by law enforcement's basically commands to not go in the home. that the victim did report that she had been assaulted a few days ago, and she had evidence of that. In addition, she also had injuries that was a little bit older related to something that had occurred with a scissors. That's very concerning for victim safety. And then the defendant's demeanor while law enforcement was on scene. So for those reasons, we are
I don't know, I've
requesting
been
the court
running.
set a cash or surety bond in the amount of $6,000 cash or surety. I am requesting pretrial supervision, and I am fine with an exception for phone contact as well as some sort of an exception for property.
I also want to say, like, the incidents with the pistol, that was my mother-in-law's gun that was taken and used in that situation. And it was left here for me to protect myself.
He's got my money in his pocket.
Yeah. And yeah. I don't know. I would like to eventually get my pistol back, or my mother-in-law would like it back, but I mean,
Also, I don't care if you people think I'm crazy or not. I would like for you to watch out for him. Make sure he's not in danger.
Does the defense wish to be heard in regards to bond and or the mandatory protection order?
Yes, Your Honor. As far as the protection order goes, we would not be opposed to having the written contact. So whatever contact the alleged victim likes, we are okay with that. And regarding the property in the home,
okay with
we
phone
also-
calls, that's fine.
we also would request a civil standby. He does have property at the home that he would like to go and obtain.
Yes.
He will not have a problem finding another place to stay. He has a bunch of family in Fort Collins, which I think I'd like to point to that being a reason that he should get a personal recognizance bond. He has these pending matters that have been mentioned, but he wants to be taking care of them, and will be able to do so while staying in Fort Collins with his family. He did just start his job. He's a flagger and has been doing that for some time, but he started his most current job recently, so he doesn't have much money built up, can't afford anything on bond. So that's why we're requesting a PR bond, and if not, the lowest cash surety the court is willing to grant.
Thank you. The court is going to issue a mandatory protection order today that will order that he not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts that he is alleged to have committed, that he vacate the home of Miss or building, that he have no contact with her directly or indirectly except for telephone contact. The court will also authorize a one-time civil standby back to the residence for him to pick up any of his undisputed personal property. He will be restrained from that East 2nd Street in Alt. Additionally, the protection order will order that he not possess any weapons, firearms, or ammunition, and that he comply with the court's relinquishment order. In regards to bond, the court would note that he is in a risk category of 3 with a total risk score of 14. His domestic violence screening instrument score is a 14. At the time of this alleged offense, it looks like he's on supervised probation out of Larimer County in 3 cases and is also on pretrial services in another case, all of which is very concerning to the court. The court also has concerns for the listed victim's safety based on the information in the affidavit that appears to have been more than one incident. The court is going to set bond in the amount of $3,000 cash or surety with conditions that Mr. Tolliver comply with pretrial, comply with probation, sign and comply with the mandatory protection order, remain law-abiding, not possess any weapons, firearms, or ammunition. Mr. Tolliver, your next court date out of custody will be June 18th at 11 a.m. in Division 8. If you remain in custody, it will be June 5th at 9 o'clock in Division 8. Do you have any questions that I can try to answer for you today, sir? And I did not receive a response. It looks like you shook your head no. Okay.
It was just all the allegations was false, right, today. That's all I got to say. That's all I got to say.
Thank you, sir. Court's in recess on this case.
All right, Mr. Reynolds, did you watch that video that talks about your rights?
Yes, I did, sir.
And did you understand those rights?
Yes, sir.
Can you waive for the reading and advisement, Ms. Deer?
Yes, Judge.
All right, let's talk about bond and the protection order. Mr. Perry?
Your Honor, we are asking for a no contact protection order. I think this probably was more situational than the one in which the parties knew one another. So hopefully that will not be an issue, but we're still asking for that no contact.
What about the address restriction? That is on the protection order?
Is it on there for the
It-
residents?
It is.
Mm,
I can cross it off if you want me to cross it off.
I think in this instance, I would, Your Honor.
Sure.
I think we just kind of did that.
They do sound
but,
crazy.
This is probably one in which that's not necessary and it's not information that needs to be known.
Understood.
So I appreciate the court. I of course, have some concerns here. Mr. Reynolds indicated that this was kind of a self-defense situation. It doesn't look like that from the other circumstances, and he does have a pretty significant criminal history, especially for his age. Not a lot of failures to appear in the last 5 years, but
Thank you so much for the cheers, Monica.
I don't know if some of that, I didn't have a chance to look, might be due to the nature of one of his last felony cases, and if he was in prison, I don't know. He was asked to cooperate with the CPAT and did not. I have some mental health and some substance abuse concerns. He does have a regular history to include that it's an old case, but attempted escape, an assault 2. It does not look like a DV according to this, but a strangulation, and as well as some other somewhat assaultive convictions, a lot of dismissals, but also convictions for violating protection orders. So I do have a pretty significant public safety concern. Not so much a flight concern, because I know he's been in this area just from looking at his criminal history, but I don't have any other information about any stability factors in the area, and I think probably some of that is what led to this offense. And then finally, as noted on the CPAT, he does have a couple of other misdemeanor cases pending.
All right, thank you, Mr. Perry. Ms. Deer?
Yes, Your Honor, Mr. Reynolds is a lifelong resident of Grand Junction. He has family in the area. His wife and kids live here. He has 2 children, 8 and 9 years old. He does provide for them financially. He has a job as a carpenter in the area. In terms of the last felony from 2021, he finished parole successfully. And so he, I think that to his credit, was able to comply with all of the demands of parole. He is living with his family. In terms of this specific case, I would agree with Mr. Perry that it doesn't seem like it was directed at this specific alleged victim for any kind of personal reasons. Mr. Reynolds does tell me that he does have some mental health disorders. And so he is, interested in treatment, not only for that, but for some potential substance use issues. In terms of his prior FTA history, he has one FTA for the past 5 years, 13 overall. He, in terms of not participating with the CPAT, I'm not sure what the circumstances are, but it's very possible that he didn't understand that. And so I would ask the court not consider that. He was able to speak with me and did participate in speaking with me in terms of these issues. He could abide by the protection order. He could also do any kind of pretrial services testing. In terms of this specific case, I think the affidavit is also unsure on whether he had, any kind of machete or weapon in his possession while he was approaching the vehicle, or when he was had it out when he was leaving, or had his back turned. And so I do think that there is some a doubt there. And so We would ask for a personal recognizance bond in this case, Your Honor. I don't think that there is a significant community safety risk, and it seems that Mr. Reynolds is pretty good about coming to court and resolving his criminal legal issues.
Sir, I just want to go home to my wife and kids, man. I apologize for all this.
All right, thank you, Mr. Reynolds. Well, the court struggles with what to do specifically on Mr. Reynolds' case. The court would note that I agree that I don't see that there's a significant flight risk concern. The court would agree with Mr. Perry that it appears that this was sort of a random incident, so I don't have a concern of ongoing safety to the victim, Mr. Girton, in this particular case. But I do have community safety concerns. Obviously, the allegations in the case are serious from the court's perspective. The allegation of brandishing a sword and swinging a sword at people for reasons that appear to be related to some sort of a delusion potentially or something like that causes the court concern. And it's hard to have non-monetary bond conditions that can specifically address that. And so unfortunately, the court finds that at least right now, I'm not aware of non-monetary bond conditions that can adequately address the court's concern. And so I don't feel that a PR bond would be appropriate here today. What the court is going to do is I'm going to set a $5,000 cash-only bond. I'm going to make a condition of that bond that Mr. Reynolds report to pretrial services if he posts it, so he'd need to report there immediately upon release. I am going to order as a condition of the bond that Mr. Reynolds not use or possess controlled substances without a doctor's prescription, no use or possession of marijuana without a valid medical marijuana prescription, and pretrial will be authorized to test to make sure that he's in compliance with those conditions. The court is also going to order that Mr. Reynolds not have any sort of weapons as a condition of his bond. The court is going to issue a mandatory.
Please.
Mr. Reynolds, here's the situation. So today, this is just the initial setting of bond. I promise that you'll be able to address bond again in front of your assigned judicial officer at your next court date. This is just my determination here today, sir.
I won't do anything bad, man. Please, I just want to be with my wife and kids, please.
Well, you're going to be able to address that with Judge Flynn next week. Okay. And so the court is going to issue a mandatory protection order that says that you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts that you're charged with committing. I'm also going to order that you not have any sort of contact with Eric Girton and that you not possess, purchase, or control a firearm or other weapons. Do you understand those terms and conditions of your bond, at least right now, Mr. Girton, and this mandatory protection order?
Mr. Reynolds, Judge.
Or sorry, Mr. Reynolds, I'm sorry.
Sir, please, I'm asking, please to reconsider, please. I just want to be with my wife and kids. I'll do everything I can.
Mr. Reynolds, I've made my bond determination here today. You're going to be able to address that with your judge later on, but do you understand the conditions that I've set today?
Yeah.
Okay. I have to advise you that violating the mandatory protection order could subject you to punishment for contempt of court. You could be charged with a misdemeanor, or you could be charged with a felony for retaliating against or intimidating a victim or witness of the crime charged.
Sir, I don't want to talk to anybody but my wife and kids, man. Please, I'm going home to them.
I know. Well, there's nothing about, you'll be able to potentially talk with them. It's just that you can't have that contact with Mr. Girton, Mr. Reynolds.
Your Honor, may I make an additional record?
What additional record?
Well, I would just say that, if the court is concerned about mental health issues, I don't think that staying in custody is necessarily going to help that with Mr. Reynolds. I don't know if he's going to be provided the adequate care that he needs in custody. And so
I'm concerned about community safety issues. That's why I'm setting the bond that I'm setting in writing the applications.
I don't want to hurt nobody. I just want to be home.
And so this case is assigned to Judge Flynn's division. I think that Judge Flynn is out next week, and so this is going to be heard in front of Judge Lawrence. So it's assigned to Division 11, but it's going to return in Division 10 on June 2nd at 8:45 a.m. Mr. Reynolds, would you like us to appoint the Office of State Public Defender to represent you on this case?
Yes, sir. I just want to go home to my wife and kids, man.
All right. Well, then, Mr. Reynolds, you'll be allowed to readdress the issue of bond in front of Judge Lawrence next week. Thank you. Ms. Gregory, did you have the opportunity to speak with Mr. Fouts?
Yes, Judge, I did. Thank you.
All right. Thank you. And so can you waive further reading and advisement at this time then, Ms. Gregory?
Yes, Judge.
Okay. Did the prosecution wish to be heard on bond for Mr. Fouts?
Yes, Your Honor.
Okay. So I'll have Mr. Cross go ahead and take it first. Go ahead.
So first, I want to go over what we're asking. Oh, sorry. First, I want to go over what we're asking for, and then I want to go over why we're asking for it. First, we're asking for a no contact order for victim and her daughter. In that no contact order, we're asking for a box 1 as well as box 4.
That's my daughter too.
Mr. Fouts, you need to control yourself and not have any sort of outbursts in court right now. Right now, the prosecution is going. You'll have your opportunity with your attorney here in a second, but right now it's the prosecution's turn. So stop.
I'm sorry. I'm sorry.
It's okay. I'm going to mute you if you have another outburst.
I apologize.
As well as box 4, 5, and 6. We're also asking for a cash-only bond with the bond conditions of GPS monitoring.
I think he is laying down-ish. Now he's picked his head up, right? I think he is laying down.
And no access to firearms. We are asking for this for 2 main reasons. The first is we believe he's not likely to appear, and the second is we believe he poses a threat to the victim's safety.
Mr. Fouts, again, I've instructed you beforehand to not have these outbursts, and so you need to not have any sort of outbursts. The court won't tolerate it, and so just stop doing it. Okay. It's not helping your case either.
I'm sorry. I'm just overwhelmed with this.
Okay. Thank you, sir. Mr. Cross?
First, the failure to appear risk is high. I want to go over why he appeared today. So he's on probation for domestic violence situation. Then he violates 2 protection orders, and then he just disappears. Luckily for the court, he was picked up in a different county and forced to appear today. I don't think that without this compulsion, he would have appeared today. Next, I want to go into our concerns with the victim's safety. The victim states that she's fearful for not only herself, but also her 5-year-old daughter. The defendant has consistently threatened to kidnap her 5-year-old daughter.
What? Okay, 1 second, Mr. Cross. Mr. Fouts, I am going to give you a warning here. If you continue to have outbursts while somebody's making their arguments in court before it's your turn, I am going to hold you in contempt of court. Okay?
But I didn't say anything like that.
This is your first warning, sir. I am going to hold you in contempt of court if you continue to have outbursts while the other party
I'm sorry. I'm sorry.
Do you understand my warning, sir?
Yeah, I understand.
Mr. Cross?
We believe the victim will be unsafe. He has already violated the restraining order here. He has been quoted as saying, "No restraining order is going to keep me from our daughter. I will die if I have to get to her." This just shows a blatant disregard for the court and the legal processes, and I don't think a restraining order would keep the victim or her daughter safe. He also has said, "Block me all you want, but you're not going to keep my daughter from me. Understand that, period." And here, the offense is that he direct messaged the defendant or the victim on Instagram, even after she had made attempts to block him on everything, even after she had gotten a restraining order. So as I've argued, I don't think the victim is safe if he is let out. I also think that he will not come back to court if he is let out, which is why we're asking for the no contact order as well as the cash only bond. Additionally, I know that the Brady Act does not apply, but because of the blatant disregard of the court in terms of saying no restraining order will stop me from seeing our daughter, I believe that no access to firearms is a necessary condition of the cash only bond. Thank you.
Thank you, Mr. Cross. Ms. Gregory?
Yes, Judge, if I could just ask for some clarification from Mr. Cross. Was this this position from the alleged victim information that they received recently since he was arrested, or information from several years ago when the cases were initially filed?
Yeah, I mean, the court normally wouldn't require that, but the court had the same question. Is it recent information or from back in 2023 and 2022?
1 second, sorry.
Sure.
So the quotes are out. I can't disconnect. Chat it. It's from this one. That was from recent ones. That's that one. Where's the other one? This one. Yeah, this one, I think. So the quotes are from the 2022.
While they're looking at that, Mr. Perry, are you appearing on any other cases today?
No, Your Honor.
And Judge, while they're looking at that, the sergeant just informed me, and it appears to be correct. I think Mr. Fouts disconnected. I don't see him on WebEx.
Oh, I didn't notice. Thank you for letting us know. All right, well, we'll see if he comes back here in a second. Why don't we check on this and let us know when you know. We will wait till Mr. Fouts comes back to get the answer, but did you locate the answer?
Yes, Your Honor.
Okay, so we'll wait till Mr. Fouts comes back. We're going to call another case in the meantime then. So what I'm inclined to do is call Damon Pollard. This is 26M 1493. The court note that Mr. Fouts had some connection issues earlier as well, and so I would just note he got disconnected earlier as well. I had seen that happened before.
You said Mr. Pollard, Your Honor?
Yes, Mr. Pollard. This is 26M 1493. Mr. Pollard, did you watch the video that talks about your rights?
Yes, sir.
And did you understand those rights?
Yes, sir.
Can you waive for the reading and advisement, Ms. Gregory?
Yes, Judge, I can. Thank you.
All right, and so let's talk about bond and the protection order. Mr. Rocky and Mr. Cross.
All right, I'll be hearing on this one, Your Honor. Just give me a moment to pull up my notes.
From the court here.
So as far as Mr. Pollard is concerned, this is a very aggravated case. Obviously, the charge that the officer put was the harassment following. I did see the court found probable cause for physical harassment, which I think is appropriate here.
He put on the ticket the physical harassment. I think there was just a typo on the
Mistake
first page. But
Yeah, I believe that was the intended charge. But the history is very concerning. There's at least 5 DV priors that I saw on the pretrial report. He's already on bond for a DV case. I think that one's set for trial. He declined the CPAT. We just looking at the case, it's not necessarily that we have flight risk concerns, but it's really the very high victim safety concerns, just given the aggravated nature of what's in the affidavit. We did reach the victim prior to this case. She's not present here, but is wanting a no contact order. The statement we got from her is that she's not scared if he gets out, but wants to be left alone. So I don't think she's opposing a PR bond, but she is wanting a no contact order. I would also ask for the address restraint as well. So as far as the no contact order is concerned, we'd be asking for standard terms and conditions, no contact, the address restraint, and then Brady would apply here. So we'll be asking for the weapons affidavit. As for bond is concerned, I do have serious victim safety concerns given the history, given the fact that he's already been on bond. So I would be asking for a cash bond to address those concerns. As for non-monetary conditions, be asking for pretrial services supervision. But that would be sent to the request, Your Honor.
okay. All right, thank you, Mr. Rocky. Ms. Gregory?
Yes, Judge, no objection to the no contact order. We would be requesting a one-time civil standby. However, we are requesting a personal recognizance bond for Mr. Pollard for a few reasons. First, Mr. Pollard has said to me, and the implication that I've gotten from speaking with him is that like many domestic violence allegation situations, when there's a protection order in place, that there have been allegations of consensual contact between Mr. Pollard and the alleged victim. And then, of course, the allegations in this case appear to have escalated past that point. And so I do have concerns in this case that the alleged victim may be wanting to have some contact with Mr. Pollard sometimes, but not when allegations like this arise. And so I think that is appropriate for the court to consider, just because the allegations are that these people were in a relationship very recently.
Very long.
Mr. Pollard has another place to live locally. He appears in court with Ms. Page, who represents him on the other protection order case in Division 14, and he's had good contact with her. Mr. Pollard was not working because he was the primary caregiver for his daughter, but now that she's out of school, and he was the primary caregiver for his daughter, but is not looking for work. She's out of school for the summer, and then the protection order and all of that stuff complicates things as well. Mr. Pollard does have a history of stroke and suffers some chronic pain from that as well, but has no other significant medical concerns. He is worried about having access to appropriate pain medications because they may be controlled substances, which can't be distributed in the jail. Mr. Pollard also very openly told me that he's struggling mental health-wise with the end of this very long relationship and recognizes the need to use his Medicaid benefits to try and get some mental health treatment as well. Because he is not working and is receiving Medicaid, I am very confident that he'll qualify again for public defender representation. He does not have any monetary funds to post a monetary bond. So for all those reasons, we are requesting a personal recognizance bond, no objection to non-monetary conditions.
All right, well, in this particular case, the court has very significant concerns for victim safety. The court would note that it appears that Mr. Pollard has 5 prior domestic violence convictions. He has pending cases that are going on right now involving the same victim. He's been accused of violating the protection order already, and then in this particular case is being accused of violating the protection order again. And so unfortunately, I don't have any sort of confidence that Mr. Pollard would follow any non-monetary bond conditions that the court would impose. And so the court declines to do a personal recognizance bond. What I'm going to do is set a $5,000 cash bond in this particular case. I am going to make a condition of the bond that Mr. Pollard reports to pretrial services supervision. I am going to issue a mandatory protection order that says that Mr. Pollard shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts that he's charged with committing. Further, he shall vacate the home of the victim, stay away from the home of the victim, and stay away from any other location where she would likely be found. Specifically, he cannot go to 18th Street, Grand Junction, Colorado, 81501. Okay.
All right, well, whatever.
Just 1 second, sir. Just 1 second. Is it?
It should be 619.
On the proposed protection order, so I'm going to change it to 6. I am going to authorize a one-time civil standby, so you'd be able to pick up belongings with law enforcement present, Mr. Pollard. I do find, I forgot to talk about the no contact. I am going to order no contact with Lacey Pollard. That would include direct or indirect communication with her, and so no contact at all, no exceptions at this point. I do find that Brady applies, and so you can't possess, purchase, or control a firearm or other weapon or ammunition. Further, you shall relinquish, meaning give up, any firearm or ammunition in your immediate possession or control or subject to within 24 hours of your release, Mr. Pollard. You'd also have to come to the courthouse and fill out an affidavit documenting that you gave up firearms or ammunition or that you don't possess firearms or ammunition within 7 days. This case is assigned to, well, first of all, do you understand the terms and conditions of the protection order, Mr. Pollard?
Yes. I understand the conditions. I just don't understand why I can't see my daughter.
Right now, the protection order is with respect to Lacey Pollard, and so I'm not putting your daughter on the protection order right now.
Judge, would the court clarify the Lacey Pollard, who is an adult? I believe his dad.
Oh, yes, they're both Lacey. I forgot.
Yes.
Yes, sorry. It's Lacey Pollard Sr., date of birth 8/16 of 1979. Sorry, I forgot that they both are named Lacey.
Yeah. Whenever I've had a restraining order against me to be at the house, I've always obeyed it.
Don't say anything else, okay?
I'm just telling you right now what the conditions are. You are going to be able to address a bond in front of Judge Grattan later this week, but do you understand those terms and conditions right now, sir?
No, I can't talk about another bond hearing because I have no money at all. If anybody was to pay my bond,
I'm not asking that right now. What I'm asking right now is if you understand the conditions of the protection order.
Yes, I do.
Okay. Thank you. I do need to advise you that violating the mandatory protection order could subject you to punishment for contempt of court. You could be charged with a misdemeanor, or you could be charged with a felony for retaliating against or intimidating a victim or witness of the crime charged. This case is assigned to Division 14, so Judge Grattan's division. What I'm going to do is I'm going to bring you back in a couple of days so you can readdress the issue of bond in front of Judge Grattan. I'm going to have you return. Does he already have your office on the other cases, I think, Ms. Gregory? Is that right?
Yes, Judge. We have she has Ms. Page.
Then I'm going to bring you back tomorrow. So Wednesday, May the 27th at 1:00 p.m. in Division 14. Mr. Pollard, would you like us to appoint the Office of State Public Defender on this case as well?
I'd like to have the same attorney that I've been using.
Okay, yeah, they figure out who's going to be specifically assigned, but we'll appoint public defender, and they'll be with you tomorrow to address your case. Thank you, sir.
So
tomorrow at 1.
Tomorrow.
All right. It looks like Mr. Fouts is back with us. And so, Mr. Fouts, are you still, can you hear us now?
Yeah, I'm sorry about that. I ended up pressing a button. It kicked me out. I apologize.
Okay. Well, we've got Mr. Fouts back with us. We'll go back on the record in 23M1759, 22M2917, 20M1484, and 21M227. Where we left off is there was some information from the prosecution about when they last touched base with the victim, Mr. Cross.
Yes, Your Honor. We've spoken to the victim about this case post the defendant being arrested. The victim wanted the no contact order. She specifically asked for one. She also asked that her daughter be placed on the no contact order as well. The no restraining order quote from earlier is from 2022. And the victim said that she was fearful for herself in this case and that she feared that her daughter would be kidnapped if the defendant was released. And that was regarding this case.
Was that in the recent information?
This is
or-
recent, yes.
Okay, all right, understood. Let me turn it over to Ms. Gregory then. Ms. Gregory?
Yes, Judge, thank you. We are requesting personal recognizance bonds for Mr. Fouts in all of these cases. I believe that's appropriate for several reasons. First, it doesn't appear that Mr. Fouts has had any contact with the alleged victim recently since these allegations, or the newest allegations in 2023. Mr. Fouts tells me that he has been living in Pueblo County for a while now. He doesn't have any Pueblo County cases, doesn't have any other open cases, and was arrested solely on these cases. He recalls telling his Mesa County probation officer that he was struggling with homelessness, had been homeless and unsupported in Grand Junction, and that he wanted to transfer his probation from Mesa County to Pueblo because his family lives there. And he did not recall the probation officer's response, but I think it is clear from the warrants that were issued in this case that that transfer didn't happen. Mr. Fouts does have significant stability in Pueblo, which he did not have in Mesa County.
I think the food would taste better that way, Micah.
Works full-time at Walmart and lives with his brother. All of his family is in Pueblo, and he does have a working phone. It was on his person when he was arrested on these warrants in Pueblo County, and so it's in property, and he would be able to have that phone, and it would be turned on as soon as he was out of custody. I think that's important because he would be able to appear virtually for court. Additionally, Mr. Fouts said that he could appear in person for court from Pueblo with enough notice. I also think he might need to check in with probation in person since they won't effectuate a transfer while he's in revocation. Mr. Fouts is unable to pay a cash bond and would request a personal recognizance bond. It's my understanding from him working at Walmart, living with family, and receiving some government benefits like EBT that he would qualify for public defender representation. So I do think the argument that he cannot post a monetary condition of bond is valid. I recognize that these warrants have been outstanding for a significant amount of time, but to Mr. Fouts' credit, I didn't see any other cases in that time, and it appears that despite these warrants, he has been a productive member of society in the Pueblo community. There are non-monetary conditions of bond and the no contact order that the court can impose to assuage any concerns. And again, of course, the phone and transportation from Pueblo to Grand Junction assuage appearance concerns. And long story short, Judge, Mr. Fouts is much more stable and on his feet.
So the marathon's going to be an attorney in trouble, I believe. I just have to get it together. I got 4 videos. I'm gonna try to make them like 1 to 2 hours each. That's what the marathon's gonna be, guys.
In a way that he was not years ago when he missed court and caught these warrants. So for those reasons, we are requesting a personal recognizance bond with non-monetary conditions. Thank you.
Well, the court declines the request to modify bonds or increase the bonds in these cases. Quite frankly, Mr. Fouts in the probation cases is alleged to have absconded from probation since December of 2021. And he hasn't attempted to contact probation to settle these warrants or to deal with them ever
that's
since
not true.
2021. And so for
I
that
emailed
reason, the court is not going to modify the bonds. Quite frankly, the court would be detaining Mr. Fouts on no bond if this case had been in Division 1. However, these cases are in Division 14. And so Judge Grattan has set cash or surety bonds. The court can't find that those are unreasonable. That same logic would go towards 23M1759 and 22M2917. The court just doesn't find that there's a high likelihood that Mr. Fouts is going to show up to court or
Yes, I
comply with
will.
any other orders of the court. And so
Yes, I will.
the court is going to issue a mandatory protection order in 23M1759 that says that Mr. Fouts shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts that he's charged with committing. I'm also going to order that he not have any sort of contact with Jonia or Joni Bots.
Janae.
Janae. Okay, well, you know who we're talking about. You can't have any sort of contact with Janae Bots. And so those will be the conditions of the protection order. I consider the request to add the Brady provisions to this protection order, but I'm not going to in light of the nature of the allegations. He already has mandatory protection orders in the other case that should govern some of those Brady provisions.
Thank you,
And so I'm
Holly. I
not going to
appreciate it.
impose
Thank
them as
you.
part of this mandatory protection order. With respect to adding his daughter to the protection order, I think that she's already on the protection order in 20M1484, and so I'm not going to add her to this particular protection order. I don't have any information right now that his daughter is a victim or witness in this specific case, and so that's
She's
why I'm not adding her to this protection order. Mr. Fouts, do you understand the terms and conditions of this mandatory protection order?
I do. That's why I haven't contacted her.
Okay, I need to advise you that violating this mandatory protection order could subject you to punishment for contempt of court. You could be charged with a misdemeanor, or you could be charged with a felony for retaliating against or intimidating a victim or witness of the crime charged.
I know.
These cases are assigned to Division 14, so Judge Grattan's division. What I'm going to do is have them return on Friday, so May 29th at 1:00 p.m. Mr. Fouts, would you like us to appoint the Office of State Public Defender so they can help you and potentially readdress the issue of bond in front of Judge Grattan on Friday?
That's fine.
Okay, then they're going to be appointed and they'll be with you on Friday, 1:00 p.m., May 29th. All right.
Great.
Thank you, Mr. Fouts. You can go ahead and disconnect, sir. Thank you.
So Mr. Fouts
Grand Junction,
had court
Colorado,
today.
81504. So you can't go anywhere near that address. I'm also going to order that you not have any sort of contact, which would include direct or indirect communication with Tracy Richardson. Do you understand those terms and conditions of this mandatory protection order, sir?
Sir, I understand everything perfectly. Thank you.
All right, I do need to advise you that if you were to violate this mandatory protection order, you could be subject to punishment for contempt of court, you could be charged with a misdemeanor, or you could be charged with a felony for retaliating against or intimidating a victim or witness of the crime charged. I'd also point out that if you violate this criminal protection order, the bond provision that we were talking about beforehand wouldn't apply. The court would be able to detain you on a cash-only bond. And so those are going to be bond conditions. Mr. Richardson, this case is assigned to my division. We're going to bring it back to court on Monday, June the 15th at 9:30 a.m. in the First Appearance Center. So if you want legal representation, make sure to either apply for public defender or seek to hire an attorney before that court date, sir. Okay?
I understand, sir.
Thank you,
Come to an
sir.
application, okay?
All right, the court is going to call James Allen. This is 20.
I don't know why I threw that last guy in there. Oops. Wow, that last guy. Whoo. All right, guys. Thank you so much for coming out. I really appreciate it. No stream tomorrow morning, but there will be one tomorrow night. I'm shooting for Monday as a marathon day. That's my goal. I just got to get. I have my 4. Zach told me that this attorney disciplinary hearing is spicy. So he sent me four videos. So I just need to edit those so they're not, a 17-hour marathon. And then we'll be ready to go. But thanks for coming out. I hope you guys have a great day. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh,